Hey, good afternoon. Carl Rominger here, coming live from the WHP studios. 540-0580, 540-0580. Call in with your legal questions. And if you don't have a legal question, call in just to chat, talk about the weather. Well, is it going to rain, Shane? Is that what's going to happen?
I hope not.
540-0580. We don't have a weather department here. I mean, we don't know the answer to that.
We do. It's supposed to be scattered if you listen to the forecast. It's supposed to be, popping up thunderstorms.
Gotcha. I was putting rubber bands in my goatee when that was on, apparently. All right, 540-0580. All seriousness, calling with your legal question. We'll answer it here on the air. I just got an email that popped up, and somebody wants to know, I mean, literally just popped, is there anything I can do to have a fine refunded and make points disappear? Well, what I get out of that is, sounds like somebody has gotten a ticket, and now they have discovered that they have points. Folks, when you have a traffic ticket, speeding ticket, driving under suspension, which would be a more serious ticket, I hope you to go see a lawyer about that one, but any kind of traffic violation is going to potentially carry points. Even if you're not a CDL driver, you've got to worry about how that might impact your insurance. And a lot of times when folks come to me and they have a point issue, I discovered that they've gotten 3 tickets and they've never fought any of them. They just sent them in, and now we've got to win number 3 when we could have won number 1, could have won number 2, or could have won number 3 to let them keep their license or prevent a departmental action and even higher insurance. And sometimes you don't even do anything wrong and you get a ticket and you figure, well, I'm just going to send it in to avoid the hassle, and then you get the points and the fine and the insurance and premium increases. According to this email I have, it's not clear when she had her points assigned, but that meant she must have pled guilty or been convicted and paid the fine. And paying the fine is a conviction. It goes on your permanent criminal record. So remember that. And then it looks like she wants her points to disappear. Well, your points are not going to disappear. They fade off slowly on their own, but the traffic violation stays on your permanent driver's record even after the points are gone. So just because the points have disappeared doesn't mean that every police officer that pulls you over and every insurance company that wants to issue you insurance can't see them. And the summaries are now available publicly on the computer system. So until you get it expunged, and you have to wait 5 years, and then you have to pay a lawyer to expunge it, it's going to sit there. So the other answer is, since I don't know how long it's been, you only have 30 days from the time you pled guilty, paid the fine, or were found guilty. And if that's the case, then within that 30 days, you can reopen the matter, and the points will have to come off your record, et cetera, et cetera. So hopefully she's listening. 540-0580. If you have a legal question, call in. Let's see, BP. What are they going to do to BP? Well, there's a lot of legal remedies. They could go after them criminally. They go after them civilly. The government could bust them up. But if you're paying attention to the news, you notice that the British government is starting to fight back, because it turns out millions and millions of citizens in Britain are dependent upon BP for payment of their pension funds, directly and indirectly, as are millions of Americans and large institutional investors. So now the president, who would, like to smash some heads together allegedly and tear the heart out of BP and do all those things that he's trying to ruminate towards, probably can't, because the reality is you and I need BP. Killing it as a company would not help anyone. 540-0580. Larry, you're on WHP 580 with Carl Rominger. Larry?
Yes.
Yes, how are you?
Good, I'm fine. How are you doing?
Good. What's going on?
Hi. Yes, I did some work at a residence.
Okay.
And it was done under the authorization of the contractor, general contractor.
Okay.
I acted as a subcontractor. And the conditions of the terms were based on good faith. And it was to get paid in 3 payments, $800 to start, which I did receive, and $800 after the rough-in, and $800 after fashion plumbing was installed. And after the rough-in, they did not pay me. The job was performed correctly, and it passed inspection. And I didn't get paid for the second payment. And I did file a notice of mechanic's lien.
Mm-hmm.
And so I'm waiting for the 30 days to be up. I did receive a letter from the owner, and I'm willing to negotiate. However, at the bottom of the letter, it says, please refrain from contacting me, after he asked me about 7 different points.
is the letter directly from him?
Yes, it is. It's signed by him, but I don't think he drew up the letter. I think either the person that financed the job or the general contractor drew up the letter and had him sign it.
Well, the answer is I would draft a response and send it to the general contractor and the other folks, and I would copy it to him with a letter that says, hey, I'm not sure. You asked me a couple questions or made a couple points in your letter, then asked me not to respond, so I was unclear. Am I to respond to you, or is there another party that you want me to respond to? And here's my response.
Well, he did. One of the points is that the financer and had trouble with the first general contractor, so the person I dealt with was the second general contractor.
Mm-hmm.
And at the bottom he says that my issue was with the first contractor. However, before the job, when the job was laid out, the second contractor gave me his business card and said that I was working with him.
Okay. So, I mean, you have your mechanics lien filed, right?
Well, I have the notice of the mechanics lien. I have to wait 30 days after to file the actual mechanics lien.
Right. And they haven't objected yet.
How do you mean? Who hasn't objected?
I mean, has he? I mean, is his letter a formal objection to the mechanics lien, or does it?
I guess the letter is. I mean, it covers several points that he states, which are punitive and have nothing to do with the function of the job, and that the inspection was approved.
Well, I would I would tell you have two options. I mean, one is to follow through with the mechanics lien. The other is to simply sue in civil court, in front of the district magistrate. How many? We're talking about a few $1,000s.
No, it's only $800. The limit is $500 for a mechanics lien.
Right.
I filed it for $800, and I was willing to negotiate. But at this point, I don't feel I need to negotiate. But I think I feel along the same lines as you do, that just go ahead and file the mechanics lien once the 30 days is up.
Yeah, that's what I would do. I mean, they haven't made any effort to suggest they're going to pay you. And then your other option is, if you want to, just sue them in civil court as well through the district magistrate to sort of move things along.
Okay.
I got to imagine that if you name all the potential defendants, which would be the person who didn't pay you as well as the property owner, somebody's going to want to kick out $800 to get rid of you.
Yeah, I mean it's it's not a large. To me, it's just the principle. $800 is not a big deal to me. Probably not to them either.
Right.
But they did have some issues with the first contractor, and I think they're trying to cover that, is what I'm thinking.
Mm-hmm. Mm-hmm. Yeah, you're getting into somebody else's mess.
Yeah.
All right. Well, that's my advice.
Okay, great.
Larry, thank you very much.
Thank you for reinforcing what I want to do.
Yeah, it's always good to know that somebody else agrees with you, isn't it?
Yeah. Thank you.
Thank you. 540-0580. I'm going to take John and Carl after the break. Hey, welcome back. 540-0580. Carl Rominger here answering your legal questions. If it's your first time with the show, I'm an attorney here in the mid-state. Spend my time stalking the local courtrooms. And if you've been following my Facebook and Twitter posts, you know I've been pulling my hair out. Perry County had me come up this week to... oh, Shane's hands are going up. It's his hometown. As I say, Perry County, it's a town. He's getting mad. I go to Perry County. I drive up there to say, for trial, Your Honor. Thank you, Mr. Rominger. You may go. So what's that, 30 miles one way, 30 miles back the other way? But then they say, oh, yeah, by the way, would you like to do the next one by telephone? You got to do the first one. You got to show up for the first one, but you can do the second one by telephone. I said, thank you. They're getting there. Maybe it'll be phone for the first one and the second one someday. Anywho, then York County asks me to, and of course I posted this on Facebook as well. York County says, oh, can you file a motion to serve this guy by publication, but we need you to serve him with it so that we can act on it. Well, I'm saying, Judge, that's the problem. I can't serve him. I can't find him. So how am I going to serve him the motion about not being able to find him. And it's kind of circular, but I'll break him of it. John, you're on WHP 580 with Carl Rominger.
Yes.
Hey, John.
Thank you for taking my phone call, Carl. I'm a repeat caller. I really enjoy your program. You've got a real nice time slot here.
Thank you very much.
That's really, really nice program. Two quick questions. First, I have a central air system.
Okay.
A residential central air system. I contract with one of the local companies, HVAC companies, to come out and look at it because it wasn't cooling the house. They did a leak test on it and found no leaks and put Freon in it and charged me basically $350. And 2 days later, it went flat, meaning it's blowing warm air again.
Right.
I called them back. They said that they would be out on a certain day, and that they would call me when they came. They never came. I noticed that the check isn't cashed yet. Can I stop payment on that check? Would it be okay to do that?
Well, the answer is you potentially could do that. And you always run into the situation where then the other side says you knew you were going to stop payment at the time that you stopped payment, and this is some kind of fraud. Sometimes they can convince.
This happened they were out last Saturday. This week was pretty cool.
Mm-hmm,
so the system wasn't. I didn't use the system much until
until the last day or so.
In the week. Yeah. And now it's flat.
And the short answer is yes, you can certainly stop payment on the check, which is sort of getting back over the barrel. Like I say, though, it's a factual question, and so I'm always a little hesitant to stop payment on a check. But it's not something that should get you in trouble. But I've had clients in the past where they bought something, stop payment on the check, and then the police get involved because the other guy goes to the police and says you scammed him and you knew you were going to stop payment at the time you wrote the check, which would be a crime, by the way, if you knew you were intending to stop payment. So there's two things I like to see, which is it looks like you've documented your problem already by making a complaint about it. That helps. Number two, I would suspect that you would have more than $275 in your bank account that you wrote a $350 check on, because that's the other one that'll catch the police's attention if this person were to push it as a legal criminal issue.
Right.
And as long as you can say, if an officer were to call you up, and I counsel you never to talk to police, if you were talking to the police officer, and of course on something simple like this, you probably could without a problem. Look, I got $1,500 in my checking account. I stopped payment on this. It's not a money issue. And I call. Here's when I called them. Here's what they did, and here's when it stopped working. And really, they promised they'd come back out, and they haven't. And if they'd just come back out, this never would have happened. So this is where we're at.
Okay.
And then let them sue you, and you say, well, you warranted your services at least, I would assume, for some purposes. Now, the flip side is I don't know what the norm in the HVAC world is. What I mean by that is, what level of warranty did you have? I mean, if they put Freon in and it dissipated or went flat right away, is that foreseeable? That sort of thing.
Well, the thing is that it was leak tested. He put in 300 pounds of nitrogen, and then took the nitrogen. Couldn't find any leaks. Checked the fittings, and took out the nitrogen and put in the Freon, which is expensive.
And that's what he might say. He might say, well, I leak tested, everything was fine, I put it in, and this is just a separate problem that arose. I mean, it is possible to get your transmission fixed and then have your tire fall off. So I don't know the answer exactly, but I'm always sometimes a little leery about stopping payment on a check. But if you've done it in time,
Yeah. Okay. The other question involving state income tax. If there's an issue with where you're what's the word, contesting, let's say an assessment,
right?
And then first it's the Department of Revenue, and then from there it goes to
the Board of Finance and Review.
The Board of Finance and Revenue. Are those two parties there pretty much kangaroo courts? I mean, most people just get bounced.
No, a lot of people find relief at the BFR level, but if you don't get get relief at the BFR level, then usually you got to go to the Commonwealth Court, and then you end up with the Attorney General on the opposite side of the table.
Mm-hmm. Which is, when you say that, what are the implications with that?
Well, I mean, just that you've got to. I mean, you're in a real court with, and they have particularized rules. So the Commonwealth Court's going to want you to reach a stipulation of the factual record below. It has its own little nuance up there. You've got to kind of follow all the Commonwealth Court rules, and it doesn't proceed exactly like a normal appeal because there's no record from below. So the parties have a duty to cooperate and reconstruct an agreed to record of below for them to review and then brief. Usually, what I find in the few times I've ever been involved in those, it usually is with a corporation who's had an assessment made on some esoteric issue of the tax law, who's simply trying to find some relief, but they're not usually straightforward questions, if that makes sense. Most straightforward questions are easily resolved at the lower levels.
Mm-hmm. Okay. Do you do that? Do you do any of that? Do you do any representing at the BFR?
We have.
Okay.
All right.
I could possibly check that out with you.
Yeah, weekendappointment.com to get my contact information, John.
Okay. Thanks a lot, Carl.
All right, brother. Take care.
All right. Bye.
540-0580. Let's try not to get confused here. Carl, you're on the air with Carl.
Yes, sir. I enjoy your program. I have a quick question. What is a flat tax?
A flat tax is a tax that has one percentage rate that applies across the board. So good example. A graduated tax is one that has different percentages for different levels. And so, like the U.S. income tax, on certain income you're taxed at a lower percent, but when you make more, your percentage goes up. Okay?
Right.
So that's a graduated tax. A flat tax would be 5% of whatever you make, whether it's $1 or $1 million.
Okay.
Or it could be a flat tax of anything above a certain amount and below a certain amount, for instance, as well. But technically, what most of us would expect, and what Malcolm Forbes and the boys have always wanted, is a flat tax to say, all right, you pay 15% of everything you make, but to help the poor people out, we'll set the baseline at $20,000. So from $20,000 to infinity, you just pay 15% in at the end of the year and send it in on a postcard.
Now, what government body can enact a flat tax in Pennsylvania?
All taxes have to originate, I believe, either with the Department of Revenue or with the local boards or authorities. Or say Department of Revenue, I should say. I meant the legislature.
You mean county or township?
Yeah, or a municipal body that's authorized to do tax through its elected board. And certainly if they have a authority to do that, depending on the type of tax. But as a general rule, like a flat income tax, things like that, that would have to come from the legislature.
Thank you. Now, the next question I have is, what is the advantage and what is the disadvantage of a lease purchase arrangement for a house or property?
Well, that's an interesting question. Actually, some litigation going on one of these, and it's one of the issues is the court is saying, or the other side is saying to the court, treat it as if it were a mortgage and allow prepayment. And I'm saying, well, it's not a mortgage, blah, blah, blah. So it's interesting that what the distinction really is. When you usually buy a house and you borrow money to buy it or land, you would get a deed and record a mortgage. Under a lease purchase type arrangement, you would simply make payments on an installment sales agreement and title is transferred after, although we still consider you the equitable owner for a lot of purposes, for taxes and things like that, depending on the terms of the agreement. But nonetheless, the advantage of one is, in one case, you've already transferred title and you've got to foreclose to get it back if the person stops paying. In the other one, you don't transfer title until you're fully paid off. So it's easier to kind of kill the transaction from the seller's standpoint.
If one was going to lease a property on a lease purchase plan and wanted to do some home improvements, I heard you grumble there. What's that mean?
Well, I'm kind of laughing because I'm like, well, those are the issues that come up, right? Who gets the value of those? And absent an agreement, anything you do to improve, absent an express agreement, anything you do to increase the value of the real estate, you do at your own risk.
But as long as you'll be paying on the lease, paying the taxes, paying the insurance, the lease would hold. They just can't throw you out and say, well, you lose.
I mean, as long as if you're complying with all the terms, then yeah, you would have the benefit of your end of the bargain. And as long as the lease requires that you be allowed to stay and that title eventually be transferred, or that's installment sales agreement is what I would call it instead of a lease, then yeah.
Thank you, Carl.
All right, my friend.
Good information. Thank
All
you,
right,
sir.
take care.
Bye-bye.
540-0580. I'm not going to go to break just yet. Dan, you're on WHP 580. Dan. Oh,
Allie?
did I? Well, Allie.
I'm Allie.
Hey, Allie, go ahead.
Hi.
Oh.
I had a debt collector contact us on numerous occasions for a debt that's not mine in any way, shape, or form. And actually, it was for a mortgage on a house. They were going to foreclose on the house. The property's not ours. We're not even the same people, and it's not even the same address. Anyways, constantly sending letters back to this attorney who was contacting us. I sent letters back twice. The first time he called, they would call, and I would say, you have the wrong people, and then they would send a letter and say, this is the amount of the debt. They would include the actual person's name and information that is owed, but it wasn't us. And then they actually sent a sheriff out to post papers on a property that, it's not even listed as theirs, and there's no mortgage on it. So anyways, they did that twice. And when I got contacted again by them, I really got mad, and I consulted an attorney.
Mm-hmm.
And he said, we can sue under the FDCPA.
Fair Debt Collections Practices Act.
Yes. So that's what we did. We filed a lawsuit against this attorney's office to cease and desist any contact with us. And, we were told, and now, granted, you go through all of that, and you only get $1,000 maximum is what I understand. Is that correct?
Right. Per incident, yeah.
Per incident, okay. So they want to settle this, giving us $500. But I guess what confuses me is why are they allowed to do that? Only get charged $500 to do that. $50,000 might make them stop permanently. Well,
when the Congress created that, what they did was they wanted to put enough of a financial incentive in there to get you to go forward with it. But at the same time, I think they have to pay the attorney's fees as well.
They do. They pay the attorney's fees. And this is, I guess, what I'm confused about is I got an email from the attorney, the attorney's office. They stated that they reduced their bill down considerably from $42.92 down to like $3,500, and we're only collecting $500 out of $1,000.
Right.
But I guess what confuses me or what concerns me is that they're trying to put this through so quickly now. They want us to immediately, I just got the email, they want us to immediately approve this offer, and also they want to send a confidentiality agreement.
Right.
That the terms are to be kept confidential. Now, why is that?
That's standard in almost all settlements. I've excluded it in a few over the years, but most people want it, which is just that they don't want anybody talking about it as an agreement to settle it. But you can ask that not be in there. The problem you're going to run into is the reality is here's the next question. Do you really have you been to depositions yet?
Well, no, because he said if we do.
Well, wait. Let me. I'm just asking if you have been, because here's the thing.
No depositions.
Why don't you sit through 2 days of depositions, and you're still only going to get $1,000, okay?
Right.
And that's the problem here. So that's why $500 is a reasonable settlement.
Okay.
Listen, I don't know. Maybe you're retired and you got nothing to do, and your life is so boring that sitting in a room talking to attorneys is going to be worth your while. And I'm sure there's somebody out there right now who's like, well, that sounds pretty interesting. But the reality is, and this I always tell clients, listen, when you get to a certain point, you just kind of got to eat the crow, even if it doesn't taste so good. And here, I mean, you're not having to eat crow. You actually won.
Yeah.
And trust me, it's not an insubstantial amount of money they're paying. It's like they're paying out $4,000. I don't know about you, but you're going to have to pry $4,000 out of my hand. I ain't just giving it to you. So, anyhow, I got to go to break. But I would counsel you to settle. Obviously, I don't have all the facts, but it sounds like you won a Fair Debt Collections Practices Act case, and it sounds like your attorney's fees were paid, so you're $500 richer. And guess what? You probably did help a lot of people, because I guarantee you, whoever that attorney's office is going to figure out why what software they were using or what was screwing up. Somebody probably got axed.
So. I hope so. Okay, well then, thank you very much.
All right, I got to go to break. Thank you.
Bye-bye.
Welcome back this fine Saturday afternoon. Carl Rominger here, 540-0580 is the talk line. And, of course, don't forget we do the bonus podcast, so you'll be able to call in from 3 o'clock till about 3:45 with your questions at 540-0580. So if you're not able to get to the phone right this second, jot that down, 540-0580. Or if you want to save your questions for then, you don't want to be heard live on the air for some reason. But it will be played on the air tomorrow on the ticket at 7 a.m., 1460, and it'll be made available as a web podcast immediately after the show. And you can listen to last week's if you didn't get a chance and you weren't able to do it yet. Listen to last week's bonus podcast. It's Mark Virginis, who's the financial guru, and myself talking about estates and trusts. And we had some great calls. So I want to thank those callers, first of all, who did call in during the 3 o'clock hour. And, of course, WHP stays on with its normal programming, but we keep the phones open. It's the same number, and it's right from the studio here. It's a little delayed because we have to get things switched over and set up. But you're really going to like it if you listen to last week's bonus podcast edition. I strongly recommend it because the calls were just so great, and we had so much good information flowing. We even had another lawyer call in with some advice, so it was great, actually. Dan, I know you've been waiting patiently. Sorry about that. I tried to pick you up earlier and hit the wrong button.
That's okay, no problem. My question is, and I'm going to ask you to put on your judge's hat instead of the defense attorney hat for this question. The other day, there was a gentleman from the Chamber of Commerce who said that they were lobbying against a bill in the state legislature that would require e-verification for employment in the building trades. And I think the bill should include every employer, but that being what it is, he implied that they would sue if that became law. And my question is, where in the world would they achieve standing? And here's why I asked that. The gentleman admitted that, if the federal government does it, he has no problem with it. And I would assume that if a private employer decided to e-verify every employee that they hire, they would have no problem with that. So my question is, if the state requires it, how are they aggrieved by someone verifying that the employee that they're about to hire is a legal citizen? So where isn't that the bar that you place on standing is that the plaintiff has to be aggrieved in some manner or another?
Yeah, and well, I guess you're aggrieved when you have to check. I guess the fact that you, as the employer, have to run the check is what the aggrievement is, and that's the basis to say that it's bothering the employer. I guess the employee's aggrieved because somebody's checking their status, but the short answer is whether the law can allow it or not. I think it can. I mean, I don't see citizenship as a protected class.
Yeah, that's what got me about the whole thing. I mean, I find it reprehensible that the Chamber of Commerce would fight this legislation in the first place, and I understand why they do it. And it is. I think it's egregious that they support hiring illegal workers because they probably save the 7.5% Social Security fee that they have to pay, the tax that they have to pay, and they probably save on unemployment taxes. So, I understand why they do it. I think it's reprehensible, but I still can't understand if you'd stand before a judge and say, my plaintiff or my group was aggrieved by the fact that they have to verify that their employees are in fact legal citizens, they would be punished if they were caught hiring illegal workers. So that was my question about it. I didn't understand. In some of these cases, you hear that people who have been actually aggrieved, the judges say that they had no standing, and I don't know how he could achieve standing in that particular case.
Yeah, I don't see standing myself. Well, I mean, maybe I see standing on the theory of the aggrievement that I have to do something I didn't have to do before, but it's a routine business regulation, and it doesn't affect the protected class, so I'm not sure how it gets out the door either way.
Okay, well, so that was where you see it was from the defense attorney hat, but if you put on the judge's robe, you'd agree with me then that it doesn't seem like they have any standing because they really aren't harmed by that.
Well, but that's the question. I mean, assuming arguendo that there's some level of harm, which is even a ministerial function. I mean, what if the law said you have to run the check 10,000 times?
But the law didn't.
Well, no, I know, and I'm just saying. So the question is one time the same as 10,000? We'd all agree 10,000 is ridiculous. It's repetitive, and it costs money to have somebody do it, and essentially make hiring somebody impossible. So the way I'm looking at it is 1/10,000th of that effort still a harm to the business? I mean, arguably, just assume for a moment that it might be. I think you give them standing to litigate it, but I don't see where they can prove actual harm. Nor can they prove that it interferes with a protected class. Of course, the next thing is, do they have the standing to bring that, or would that be the employee who should be arguing that? Mm-hmm. I don't know. I'm just thinking out loud.
Okay, well, it was an interesting show, but I was flabbergasted to hear that the Chamber of Commerce was coming out. They have 5 lobbyists lobbying to make sure that doesn't become law, and they implied that they would sue if it did.
Yeah.
If I was still in business and I was a member of the Chamber of Commerce, I would quickly revoke my membership.
Well, but Dan, here's the flip side. So let's say you do take the position as a business owner and business guy that a little regulation is good because you like what they're regulating. Next time you've got it when they come to you with a regulation, you say, well, generally as a business person, I'm against regulation. They're going to say, well, that's funny because the last time we came to you, you said you wanted us to regulate things. So I think the chamber has a difficult problem because they can't. They're generally not in favor of any regulation on business, right?
Well, the gentleman said that he had no problem with the federal government mandating e-file, and it has an advantage to the business if there is a system in place that verifies whether they are legal or not. They're covered then. If they come, for some reason or another, they hire somebody and they fall through the cracks of e-verify, they at least have the protection of saying, "Hey, we verified,
right,
and you guys screwed up, so you can't charge us."
Yeah, no, I understand that. I'm just saying, I think intellectually, the chambers of commerce are generally anti-regulation. Mm-hmm. And the next question is if there already is a federal regulation, why do we need a repetitive state regulation? I don't know.
I don't think the federal is regulation at this point. It's available, and it's there. If you choose to use it, from what I understand.
Well, we've got, but they do have a whole new I-9 system, or not I-9, the W-9 or whatever that form is you fill out for new employees. I know because
it's the I-9, and I was in business. I'll tell you what, that whole thing. It was a nice start, but it was an absolute joke. I had one guy work for me under 2 different Social Security numbers, 2 different total names. And the second time he came to work for me, I said, "I know you, and you're such so and so." And he said, "No, I'm not." And what I came to realize was that groups of people would work under one Social Security number, excuse me, for a period of time while the rest of them collected some social benefit. And
right.
They would, and as that benefit came to a close. Now here in Pennsylvania, it rarely does, but if it did come to a close, that they said 5 years and out, like they're supposed to. They could rotate.
Right.
5 guys could work under one Social Security number, and that person would look like they have massive earnings.
I saw
sleep, but at the same time, the other 4 of them would be collecting, so they'd all be sharing that pot.
I saw one where where a manager of a restaurant was fired because the corporate office determined or figured out that he had one set of employees who were working 2 shifts because they each had 2 Social Security numbers. All right, Dan, I got to let you go because I got to go into break here.
Thank you.
540-0580. Carl Rominger here answering your legal questions on Weekend Appointment. And, of course, make sure you go to weekendappointment.com to get that free will. First time joining us or a long-time listener, maybe you don't know, you can go to weekendappointment.com and you can get a free will by registering and downloading the kit and sending it in. I just wrote a few of those this week. I got a few more people coming in, I think, on Monday to do them, and it's well worth your while. So if you're a husband or a wife or both, an aunt, an uncle, or you just want to leave your fortune to the Model Toy Train Association, which Shane is probably the president of, last I checked. No? Oh, okay. What are your hobbies? He's watching the World Cup, so he's not really paying attention to anything I say.
The World Cup is my hobby.
So it's interesting to see the rise of soccer. But anyhow, back to weekendappointment.com. You get that free will. So make sure you're a registered member over there. And I just posted to Facebook a picture of me with my radio microphone that they took here for me.
Is that right?
That's true. Now, 540-0580, and, of course, when we end here at 3 o'clock, you're going to be able to continue calling for 45 minutes. Remember that, 540-0580, call in. And you can also go to weekendappointment.com, post some questions. I've got a few that have come in there. Mary, you're on WHP 580.
Yes, Carl, glad to speak with you. I listen to you quite often.
Well, thank you.
My question is this. I'm a mother of 3 children, and, of course, I'm up in my 80s. But I have, with the 3, 2 daughters and my son, they're all involved with my power of attorney as far as my money and my investments and my property. Now, the oldest daughter said to me, Mother, I just found out that the state states there is a durable medical power of attorney. Do you have one? And I said, I just assumed. I said, no, I don't. I said, I can call my attorney to verify it to be sure, but I'm positive I don't have one. I just assumed. I told the daughters and our son, because our 2 daughters are nurses and so am I, that they know what to do if I'm critical and they can pull the plug. But now she said, Mother, I think the state requires it. Do you know anything about that?
The state does not require it.
Oh.
But the state has created one that they have on their website that you can download and do at home. Mm-hmm. Or I do them. And I can give you an example. When I give away the free wills, yes, I usually offer people the opportunity to get a durable power of attorney as well as a medical power of attorney and advanced life care directive or living will. Mm-hmm. Mm-hmm. And most people that are either have them or opt to get them along with the will, but it's not mandatory you have one.
Oh.
However, I tell people you should have one because if you can't, your kids are going to want to know and need to know, what to do in case something happens to you.
Right.
And so it's not fair to them to let them fight it out as to what mom or dad really wanted. Mm-hmm. It's better for them, or for a parent who has a child who's in a permanent vegetation. It's better that you hear it from them.
Oh, I see. Well, that'll make it a lot better that they wouldn't be getting into any problems.
Right, and the biggest thing is just to know for certain that that's what your wishes were. I mean, when the doctor looks at you and says, "Listen, we're not, we want to unplug Grandma," right?
Yes.
And you look at the doctor and you say, "Okay." Well, you feel a little better about it if you knew Grandma was on board with that ahead of time. You might still have to make that decision if you don't have the living will, but having the living will give you that comfort level that you know you're doing what they wanted you to do.
Okay. Well, I thank you very, very much. I think I'll do that.
All right, Mary.
All right. Thanks for being
Thank you.
Where you are because
All right.
I enjoy your program.
Thank you.
All right. You're welcome. Bye.
Bye. 540-0580, and we're going to leave that line open through the 3 o'clock hour here so you can call in and I'll answer your questions on the bonus podcast edition. And, of course, that bonus podcast is going to be replayed on the ticket And you'll be able to get it immediately to the WHP website and at the weekendappointment.com. Shane's clapping over there, so America must be doing something good. And are they, Shane? What's going on? What's the World Cup update?
Down 1-0 right now.
Oh, man. How much time they got left?
About halfway through the first half.
Okay, so they got a lot more time to go down 2 or 3 more points, probably, right?
I'm hoping so, man. I'm hoping so.
540-0580, and of course, like I told you, we're going to keep the phone lines open. And I was just answering a question about a living will, and I want to point out to you that if you don't have a will, you should get one, and it's free. So go to weekendappointment.com, register, and get it for free. If you don't have a living will, we can do that as well, and we do durable powers of attorney. You can get a will with my program that I have on weekendappointment.com. The will's free. If you want it with the living will and the durable power of attorney, you can get out the door for less than $100 per person. So I think that's very reasonable, and I encourage people to do it. And part of the reason why the cost is as low as it is, because my secretary thinks I'm crazy, is because I want people to have them. Now, remember, when the show's over here, of course, next week we'll be back on at 2 o'clock answering you live on the air. But for the next hour, we're going to leave the phone lines open. So write down 540-0580. And Tom, if you hang on a minute here, I will get to you. So 540-0580. And folks, go to weekendappointment.com. Post your questions throughout the week. Get my office number. I'm always happy to represent you. We do personal injury,